Damn it.
Yeah, that's
Okay.
great. He was thinking of like you wouldn't believe it.
Full house. Good morning. I'm David Barish, Chairman of the Pennsylvania Gaming Control Board. Before we begin, I'd ask everybody to turn off their cell phones or put them on silent. With us today is Fred Strathmer for Russell Redding from the Department of Agriculture, Jennifer Langen representing Tim Reese from the State Treasurer's Office, and Bob Coyne representing Eileen McNulty from the Revenue Department. Quorum of the board is present, and as such, I'll call today's meeting to order. First order of business, I'd ask everybody to stand for the Pledge of Allegiance. I
pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Before we proceed to the heart of the agenda, Kevin, if you would come forward, please.
Good morning, Chairman Barish. Good morning, members of the board. Director Claire Yantis of our Office of Human Resources and I are very pleased to continue the process of recognizing employees who have reached the milestone of 10 years of service with our agency. We appreciate their loyalty and we appreciate their commitment to do the very important work of our agency. So today we have a total of 27 employees who reached that milestone, and 14 of them were able to make it in to Harrisburg, and we're going to do it in two groups. First group is a group of 9, and the second group is a group of 5. Michael, would you like to come up here, and the first 9 will all get in a row here. So what these 9 individuals have in common, other than working for the Pennsylvania Gaming Control Board, is the fact that they all started on the same day, January 21st, 2006. It was a very busy day for a very small Office of Human Resources. And all 9 of these individuals, as well as several in the second group, started as Bureau of Investigation and Enforcement investigators. So I know it's probably just the answer to a trivia question, but we recently went over 64,000 applications received in Pennsylvania through our casino industry. And these 9, as well as the other 5, really got us off to a great start doing those backgrounds in a very competent way. So we're going to start with Michael Rosenberry and Michelle Seo. They were both hired as investigators in BIE. Today they are our 2 deputy directors in the Bureau of Investigations and Enforcement. Michelle oversees the investigative intake unit and the Eastern Regional Office, and Michael oversees the Central and Western Regional Offices. Congratulations, Michael. Congratulations, Michelle. Next, we have Kathy Colfer. Kathy was hired as an investigator in the Bureau of Investigations and Enforcement. She was assigned to the Eastern Regional Office, and she continues in that capacity today. Congratulations. And Joe Moraes. Joe also is an investigator with BIE. He was also assigned to the Eastern Regional Office. And he is working in that capacity today as well. Joe, congratulations and thank you for your work. Bill Gavigan is our next investigator in the Eastern region of our Bureau of Investigation and Enforcement. Bill, thank you for your work and congratulations. Jay Berthelsen. He began his employment in January of 2006 as an investigator in the Bureau of Investigation and Enforcement. Jay, for one reason or another, decided to take the opportunity to work with the Bureau of Casino and Compliance, and he is today a senior supervisor stationed here in Harrisburg. Jay, congratulations and thank you. Donna Kibbe is our next honoree. Donna began her employment as an investigator with Bureau of Investigations and Enforcement in Conshohocken, our eastern region, and she was promoted to Supervisor of Investigations, and that is her position today. Congratulations, Donna. Thank you. Richard O'Neill. He began as a senior financial investigator in BIE, and in 2010 he was promoted to the supervisor of that very important unit. Richard, thank you very much for your service. And Joe Bott. Excuse me, Joe, I identified you as a BIE agent from the beginning. No, Joe is not a BIE agent. But he helped process all of these other BIE agents and gave them the training that was very valuable in the beginning. So Joe is today an HR specialist in the Office of Human Resources. Congratulations and thank you for your work, Joe. So if we can give this 9 a hand of applause. Thank you very much. And now we have our second group of honorees. Okay, terrific. So our first honoree in this group is Chelsea Wilson. Chelsea was hired as an administrative assistant in our Office of Human Resources, and since September of 2011, she has been an HR analyst. Chelsea, thank you very much for your service. Congratulations. Next, we have Doreen Bollinger. Doreen was hired as an administrative assistant, and since October of 2006, very early in her career, she became a licensing analyst in the Bureau of Licensing in the Employee Permitting Unit. Doreen, congratulations and thank you for your service. Our next honoree is Ben Williams. Ben has been with our Information Technology Office. He was hired on January 28th of 2006 as a support specialist. He continues to perform that very important function today. Ben, thank you for your service. Congratulations. And next we have Kathy Philby. Kathy was hired as an administrative assistant for the board, but since October of 2006, she has been an investigator in the Bureau of Investigations and Enforcement stationed here in the Harrisburg office. Congratulations, Kathy, and thank you for your service. And our final honoree of the day is Deborah Davis. Deborah was hired as an administrative assistant to work in the Conshohocken Eastern Regional Office, and she is still assigned to that office, and she really keeps everybody in line, and we appreciate your work very much, Deborah. Congratulations, and thank you for coming today. So if we can have a hand of applause. Thank you very much. And you're welcome.
All of you who are honored today for your service to the board and to the citizens of the Commonwealth. Moving on, I believe we have oral arguments scheduled. The first pertains to Office of Enforcement Counsel's complaint for judgment and penalties against Greenwood Gaming. Would counsel for Greenwood Gaming and whoever else is arguing on behalf of Office of Enforcement Counsel please step forward. And I would ask counsel to state and spell your name for the court reporter.
Good morning, Chairman Barish, members of the board. Dustin Miller on behalf of the Office of Enforcement Counsel.
Mr. Chairman, members of the board, Mark Stewart, S-T-E-W-A-R-T, on behalf of Greenwood Gaming.
Thomas Bonner, B-O-N-N-E-R, General Counsel for Greenwood Gaming.
Thank you. Excuse me. Please proceed.
Chairman Barish, In its complaint against Greenwood Gaming and Entertainment, Inc., the Office of Enforcement Counsel has alleged numerous violations of the Pennsylvania Racehorse Development and Gaming Act and the regulations promulgated under the Act regarding what the Office of Enforcement Counsel considers the untimely notification to the board by Greenwood of its plan to refinance its debt. This time I would like to focus on two provisions in the regulations most applicable to this situation. 58 PA Code Section 441A11 states that each slot machine applicant or licensee shall notify the board in writing as soon as it becomes aware that it intends to enter into a transaction which may result in any new financial backers. The notice shall be sent to the Bureau of Licensing and what has become the Financial Investigations Unit of the Bureau of Investigations and Enforcement. In this instance, Greenwood entered into an agreement with Merrill Lynch on or about May 18, 2015 to seek lenders to refinance its debt. Greenwood did not provide this agreement to the board or the Financial Investigations Unit until over a month later on June 19, 2015. Prior to that date, nobody had any notice that Greenwood was seeking to refinance its debt. Further, a summary of indicative terms of the transaction that was enclosed with the agreement with Merrill Lynch indicated that the anticipated date to close on this transaction was June 30, 2015. In fact, Greenwood sent the agreement in summary of terms on June 19, 2015, which was a Friday. It was not received by the Office of Enforcement Counsel until Monday, June 22nd. At that point, as far as we knew, the Financial Investigations Unit had 6 business days to thoroughly review this transaction before Greenwood closed on the transaction. The May agreement between Greenwood and Merrill Lynch is documentary evidence of intent to enter into a transaction, and Greenwood had no definitive knowledge who the proposed lenders would be at that time. So it was possible that the transaction may have involved new financial backers, which triggers the regulation. The second regulation I want to address is 58 PA Code Section 423A6B, subparagraphs 4 and 5. And they state that an individual who has applied for issuance or renewal of a license shall execute a statement of conditions in the manner and form required by the board. The execution of the statement of conditions constitutes the acceptance of each provision contained in the statement of conditions. Failure to comply with any provision contained in an executed statement of conditions constitutes a violation and may result in board-imposed administrative sanctions up to and including revocation against the individual or entity to whom the license was issued. Now, paragraph 15 of Greenwood's executed statement of conditions shows that Greenwood agreed to notify the board on a confidential basis prior to or immediately upon becoming aware of any impending change of ownership or change in control, material change in financial status, including debt position, restructuring, receivership, merger, dissolution, bankruptcy, or transfer of assets to any third party. The transaction at issue today increased Greenwood's borrowing ability by tens of millions of dollars. Thus, it's the Office of Enforcement Counsel's position that the transaction in question qualifies under paragraph 15 in the executed statement of conditions, and notification should have been made prior to or immediately upon becoming aware that they were going to pursue this transaction, which was May at the latest. The Office of Enforcement Counsel has cited other sections of the Act and regulations that we feel are applicable, even though they primarily target applicants. It's the Office of Enforcement Counsel's position and belief that licensees should not be held to any less of a standard than applicants, and that is why the Office of Enforcement Counsel cited those regulations in its complaint. The underlying reason for these regulations is that financial suitability is ongoing for any licensee. In order for the Bureau of Investigations and Enforcement and the Office of Enforcement Counsel to be able to properly monitor the financial suitability of a slot machine licensee, we need timely notice of impending major financial transactions, such as refinancing of debt, in order to have the time and opportunity to thoroughly review the transaction to see what impact, if any, it has on the licensee's financial suitability. Thus, regulations such as Section 441A11 and Condition 15 of Greenwood's executed statement of conditions, which require immediate notice to the board when a transaction like this is being planned. This is a financial transaction that involved hundreds of millions of dollars. It's not like refinancing a home mortgage. Just the summary of indicative terms alone indicated numerous affirmative covenants, negative covenants, and financial covenants that immediately raised questions for the Financial Investigations Unit and the Office of Enforcement Counsel. And those questions were based only on a cursory review of the documents that were provided at that time. Examples of these questions include potential changes in the ownership structure and potential encumbrance of casino assets to fund developments of other projects. The Office of Enforcement Counsel and the Financial Investigations Unit were not aware of these potential events until it began to review the documents provided, and 6 business days is not enough time to thoroughly analyze these types of transactions and provide a competent analysis to the board. Greenwood may have put pen to paper with Merrill Lynch to seek out lenders on May 18th, but it is highly improbable that the decision to refinance its debt was made around that time. We are still unaware when the actual decision to refinance occurred. Greenwood should have at least informally advised the Bureau of Investigations and the Office of Enforcement Counsel when the decision was made to refinance its debt and kept us updated on a confidential basis as the transaction progressed. Other slot machines also recently refinanced debt, and in each instance, notification was given in a timely manner. Even a phone call or an email at the beginning of the process, followed by a more formal notification, is sufficient and has been past practice in all prior refinance matters, of which there have been many. In this case, the lack of any notification until the formal notification raised red flags, especially in light of the approaching closing date. The Financial Investigations Unit has an excellent staff and are veterans in reviewing and digesting the documents involved in these transactions and the attendant financial implications, but they do not have unlimited manpower. They need timely notice when these transactions are on the horizon so that they can prepare and plan accordingly. The Office of Enforcement Counsel is concerned that if this complaint is dismissed, it will send a signal to other licensees that liberties can be taken with board notification in this context and perhaps other contexts. Parks has been and continues to be very healthy financially, but other licensees may require greater scrutiny. For example, the situations regarding Foxwoods, PITG/Majestic Star, Atlantic City Coin and Slot, and Caesars spring to mind as instances where timely notification of significant financial transactions was absolutely imperative to board action. Without timely notification, the Financial Investigations Unit is not going to have the necessary time to thoroughly review these transactions and advise the board through the Office of Enforcement Counsel before the actual transaction takes place. At a minimum, the Financial Investigation Unit's review provides a second set of eyes on the transaction, and its questions could result in favorable changes to the terms of the agreement. Although involving an applicant instead of a licensee, the Office of Enforcement Counsel asked the board to take a look at the underlying principles of the consent agreement that was approved by the board in 2011 between the Office of Enforcement Counsel and Valley Forge Convention Center partners. In that particular case, Valley Forge, while still an applicant, entered into a term sheet with the lender approximately 4 months before it was disclosed to the board. As stated previously, it's the Office of Enforcement Counsel's position and belief that licensees should not be held to any less of a standard than applicants, and that is why the Office of Enforcement Counsel cited regulations implicating applicants in its complaint. While not as egregious as the Valley Forge matter, this matter involving Greenwood is nonetheless a violation of the board's regulations. In the Valley Forge matter, the Office of Enforcement Counsel and Valley Forge settled on a civil penalty of $10,000. Although in our complaint with Greenwood, we sought a considerably higher civil penalty, at this time we recommend to the board a civil penalty of $5,000 plus payment of a bill of costs reflecting the time and expense spent by the Office of Enforcement Counsel and BIE staff on this matter. Finally, even if the board does not feel that a civil penalty is warranted in this matter, the Office of Enforcement Counsel urges the board to still find Greenwood in violation of board regulations so as not to set a precedent that may hamper the Bureau of Investigations and Enforcement and the Office of Enforcement Counsel in trying to enforce these regulations in the future. Thank you.
Thank you. Greenwood?
Mr. Chairman, Mr. Stewart will make the formal oral argument. I just wanted to offer some orienting overview comments. I think it's fitting that you're honoring 10-year employees today because one of the things I'd like to talk about is Greenwood Gaming Park Casino's almost 10-year history of gaming in Pennsylvania. We were the second casino to open. We opened in December of 2006. We've been at it for a little bit over 9 years. Look forward to our 10th anniversary celebration in December. Over the course of that 9+ years, OEC has knocked on our door 22 times to tell us we think your colleagues committed some errors, didn't follow the regulations, didn't do things properly, and we're going to file an enforcement action unless we can agree by way of consent agreement, and you're well familiar with that process. 21 of those 22 times we have agreed. The 21st is before you later in today's agenda. I'm addressing the 22nd time. We don't agree. We believe that we followed the regulations. We believe that we gave timely notice to the board, as Dustin has indicated, notice was given in advance of the transaction. We gave notice the day that we finally knew who the group of lenders would be. We had lenders competing to be part of the consortium for the amendment and restatement of our existing loan. And on the day we knew who they were, we gave notice, as Dustin said, mailed it on a Friday, and it was received on a Monday. Although at that time, we did say we thought the targeted date for closing was June 30. In fact, we closed about 4 weeks after that. So the board had 5 weeks' notice prior to the closing. FIU had time to review and evaluate the transaction. And although it's important that FIU have the information available, my recollection is that no significant questions or concerns were raised by FIU. They had the terms. They didn't ask for any amendments, didn't ask for any significant explanations. They understood the deal. So there was really no concern. So my point is that we engage in tens of thousands of regulated transactions every day in our casino. On very few occasions has there been need for OEC to bring a matter before you. In all but one, this one, we have agreed that OEC had the facts that warranted an appropriate civil penalty, and we've done it by consent. We know they're not asking for much money. This is a case in which we think $1 is too much because we believe we followed the regulations and gave the notice that was required. Thank you.
I'll be brief. Thank you very much. We believe there's a very narrow issue here, which is when must notice be given under Section 441A11 of the regulations. All of the other provisions cited by the Office of Enforcement Counsel are not applicable on their face by their own terms. In terms of the comments from Enforcement Counsel about the need to ensure Parks' remaining financial suitability, we would submit that that's fairly obvious on the facts of its performance, on the fact that this board found Parks to be financially suitable 6 months prior to the refinancing, and frankly, the terms of the refinancing themselves confirm the ongoing financial suitability of Greenwood Gaming. And there's a regulation that addresses that duty to maintain financial suitability. It's 441A.11a. And if there's a concern about that, the proper avenue to express that concern or raise that concern would be for the Office of Enforcement Counsel and BIE to investigate under that regulation. If you look at its terms and the elements that are to be considered, Parks passes each one with flying colors. Turning to the question of when notice must be given, we believe that there's two elements that must be present in order to trigger the notice requirement. The first is that there must be a new financial backer or a new financial source involved. That's right in the text of the regulation. In our view, Enforcement Counsel has ignored this fact and overreached throughout this process. They have demanded notice of all refinancings, even if no new financial backer is involved. And that is inconsistent with the text of the regulation. And, you know, it may be something that has been done in the past. You saw by other casinos. You saw it in Mr. O'Neill's affidavit if you looked at that. But there's a key distinction between what is voluntarily done and what is required to be done and what can be penalized for a breach. So the first trigger is there must be a new bank involved. The second is that there must be a transaction for the casino to intend to enter into. The regulation does not require us to give notice to you of every thought or every idea that we have. Transactions, by their definition, require there to be two sides. A casino could propose terms that were unrealistic, that no bank would finance. Is that a transaction? Is that something that has to be provided notice for? Here we submit, as Mr. Bonner stated, that there is no violation because notice was timely given. No transaction existed until, in our view, until we received commitments from the lenders. Those commitments were not accepted on the date that they were received, but we at least received commitments from a pool of lenders on June 17th after 5 p.m. Notice was promptly provided within 2 days. And those commitments did include one new bank. Every other bank involved that gave commitments was a pre-existing lender. And that bank's commitment included conditions which were not accepted at the time. Negotiations ensued, and actually the participating lenders and the fact that there would be one new lender was not even confirmed until June 30th in this matter, several days after notice had been provided. So we believe that the June 19th notice was timely. In terms of the questions raised, as Mr. Bonner stated, they were not material, and they were one was about a buyback of stock, which did not even meet the threshold transaction under any of the regulations for review. The other was about a very known project finance related to another project that was before this board just months before. In terms of taking any liberties, even if this matter is viewed slightly differently factually, it's hard to believe that liberties have been taken here. At worst, we knew of the possibility of a new financial source on June 3rd. And certainly 2 weeks to get that in is not taking liberties with the notice. But again, there was no transaction at that time for us to enter into. There were no commitments. So with that, we request that you dismiss the complaint.
Thank you. I don't want to get into rebuttal and counter rebuttal here, but if you'd like to just summarize where you are briefly.
Yeah, I don't. If we want to go back and forth, and we obviously think that 441. We have a different interpretation of 441A11, and I would just ask the board to apply the plain meaning of the language in that regulation. It clearly says that as soon as the licensee becomes aware that it intends to enter into a transaction, which may result in a new financial backer. It's our position that when they entered that agreement in May, they clearly knew they were intending to enter into a transaction, and they did not know who the lenders would be, so it may have involved a new financial backer. So that's where we are.
Okay.
We'll just keep going back and forth, Mr. Chairman, I think.
I just want to make sure that we were there. Thank you very much.
Thank you.
Thank you.
Thank you.
Chairman, I do have the bill of cost that I referred to in my oral argument, and I think I would want to submit that to the board secretary. I have provided a copy of that to the opposing party, and then if you do find a violation.
Oh, excuse me. I'm sorry. I skipped something. It's always good to have a former chair to tell me when I'm drifting. If I could interrupt you. Are there questions from the board?
I just have one question for you, Dustin. You said it would have been helpful or appropriate probably for an informal contact, a telephone call or whatnot. What would you have done with an informal contact that said that there may be would their investigation begin? Would there have been any work done?
Pretty much the past practice has been is that we have gotten sort of an informal contact. Hey, we're thinking about doing this, and pretty much what we tell the licensees is, well, when you have documents, please provide them. When you know something, let us know something. That's pretty much how these have been handled in the past.
Thank you.
Well, if I may, I would say that when we did know something, we did let them know.
Okay. Other questions? You do?
Yeah.
Okay.
With all due respect, Dustin, it seems to me that this is, I'm not sure why we're here. I understand your position, but you agree with Greenwood that your interpretation of the regulations sounds to me strikingly different from Greenwood's.
Right.
And therefore, if the board were to agree with Greenwood, you understand that your position has to fall.
Yes, we do understand that. And to answer your question, Commissioner Woods, we would ask questions. There would be a dialogue back and forth. There was a lender presentation that Greenwood made in early June. We never received that. We received those because we would have a dialogue going back and forth. If you interpret it the way Greenwood argues, it would be no skin off my back. It'd be less work for us, actually, because in the end, by the time we got the transaction, they'd be nearing closing. They'd be near the closing, and by the time the board got the information, the closing probably would have occurred.
And the bottom line, Cyrus, is they can't do anything without you signing off on it anyway, right?
Yes, they can.
What?
Yes, they can. They can go to closing without me knowing anything about it.
Would they? As a
Yes, they
practical
would.
matter?
Yes, they would. That's what led us to PITG and Holdings acquisition and the whole problems with Rivers in the past. These protocols were put in place to ensure that we would not run into the same situation again with any applicant or any licensee, be that who they may be, whether they're financially fit, whether they're teetering on the brink. It has saved us in various ways with Foxwoods, Caesars, Atlantic City Coin and Slot, Mount Airy. Without knowing those things in advance, without being aware of what's going on in advance, it encumbers us from tracking the finances of our licensees. It could lead to possibly to more bankruptcies. It could possibly lead to us being behind the 8 ball and the casinos entering into transactions and us finding out after the fact and not being able to do anything about them. While I applaud Greenwood for its operations, it's not something that I think would be logical for us to do at this time frame, with the industry coming under attack in all fronts from other jurisdictions and competitions from other areas.
Mr. Chairman, I'm sorry.
Please hold.
Yes, I'm sorry.
Go ahead, please.
Mr. Chairman, just with response, in response to Cyrus's comment about we would have gone to closing, in fact, we pushed back the closing date. In part, we weren't ready to close with respect to the bank and the business terms, but in part, we did not want to close knowing that we were in discussions with OEC about a possible resolution of the disagreements that we had. We entered into a stipulated statement that we both signed, and as you know, continuing our attempt to try to do things by agreement, you have a set of stipulated agreed facts before you. We agree on what the facts are. We just disagree on the conclusion you should draw from them. But we delayed closing beyond June 30 by almost 4 weeks, in part in an attempt not to have Cyrus say we closed, giving you the back of our hand.
That closing was
In part.
delayed. That closing was delayed because I made numerous threats. Okay.
Okay.
Whatever, we listened to
Let's,
it.
okay, enough for now.
I can't believe that, Cyrus.
I have 2 questions, but did you have one?
Yeah, I do.
Go ahead.
Thank you, Mr. Chairman. I'm I'm with Commissioner Ryan. I'm not sure why we're here either. And, you know, I look at this and pox on both your houses. I think a little notice, a phone call, an email in May, early June, June 3rd, when you knew who the lender was, wouldn't have hurt. Heads up, this is coming. We don't know when it's coming. You know, if you're looking at a June 30th closing notification, you know, on June 19th, Friday, late in the day, arrives Monday, you know, the 21st, 22nd, whatever that day is, you don't know what they do. And so to assume that they can do what they need to do, both background checks on the new lender, looking, you know, at Mr. Green again, updating his background, looking at the use of funds that the money's going to go for. You can't just assume that that's going to be done in 6, 7, 8 days, 5 or 6 business days. And so a little heads up wouldn't hurt. To you guys, you know, this, again, I think that each transaction, I know you're worried that if we rule on behalf of Greenwood, that it's going to set a precedent. We don't look at it that way. We look at every transaction as a specific facts and circumstances. We have the authority on this board to rule as we wish. And if we rule in their favor and there's a similar situation down the road where somebody doesn't give you proper notice, you feel, you know, that they violated the regulations, you should come back before this board. And we will look at that transaction in a facts and circumstances test. But I really, I don't think we should be here. I don't like the fact that we're wasting time on this. And again, I think there's enough fault in both houses to be equally shared.
Two questions for you, Cyrus. Or at one, so you get the notice on effectively June 19th or whatever. Did you at that point or at any point, at what point did you express concern that you were being, when did you first tell Greenwood that you were troubled by the fact you're expected to do something in 6 or 7 work days?
23rd.
The very next day.
Yeah.
The very next day? Okay. And for you all, very common, I'm stating it as a question as opposed to Commissioner Fite. You knew you were well past the rant. I can't agree with Mr. Stewart. It was hardly a question of telling everybody every thought you ever had. You had documents, you had a lot of work that had happened by May 18th. What's the reason why? Just explain to me why you didn't let them know sometime between May 18th and
Mr. Chairman,
and June 19th.
we were awaiting confirmation of who the lenders would be in the group. We did have documents that predate that. Obviously, a transaction of it like this doesn't get done in a week. We were awaiting confirmation so that we could tell the board specifically who the lenders would be, and that's what we did when we learned who that final 7th bank was.
Okay, but the reason why I'm asking that is we're up to June 19th. You're still hoping to close on the 30th. By definition, I presume you recognize that they weren't going to have a whole lot of time to review things.
If you asked me then, Chairman, I probably would have told you we thought we wouldn't make that date, but that was the date that was in the document, the June 30 target date. In fact, we closed about when we figured we might know.
So when they contacted you on the 23rd or whatever and expressed concerns, did you tell them, don't worry about June 30?
We began extensive discussions. Part of them were about delaying the closing date. And I believe I indicated relatively early in the process, don't worry about the closing date. We'll hold off, try to resolve things before we close. And in fact, we did. That was important to us, not to close without some attempt to agree with the board.
Well, I assume that would be the case in any of your transactions. I guess my comment is similar to Commissioner Fite's, which is it was inevitable that there was going to be a disagreement given the short length of time. And to assume that because they didn't ask a lot of questions, that there was no need to give them more notice, just seems to me you guys are going to be working together for the next 20 or 30 years. And
we've been for 10. This is an aberration. But, Chairman, one other important point, I think, as you deliberate, we did enter into a stipulated statement of conditions. We agreed to do certain things, give certain notice to the board if certain things were to happen related to the financing. That's signed by both parties. That was prior to the closing. So we came to an agreement with OEC with respect to how we would handle the matter. It obviously didn't forestall this argument that we relayed anyway, but we came to an agreement on the terms that seemed to matter substantively in the deal. And we did that before closing.
I understand. Any other questions?
If I may, with all due respect to Commissioner Fite, with whom I never disagree, I'm not going to be quite as tough. I have to say, speaking for myself, I think, with all due respect to OEC, that Greenwood acted appropriately here, given the regulations, given what they were trying to do, given the situation they were in. That's all.
Let's move on to the next argument, please.
Thank you, Chairman.
very
Thank you,
much.
Commissioners.
Doesn't matter, but get through this. Good morning. Would both counsel please identify themselves and spell their names for the court reporter?
Good morning, Chairman Barish, members of the board. David Tepper, Tepper with the Office of Enforcement Counsel.
Good morning, Mr. Chairman, members of the board. Michael Sklar, S-K-L-A-R, on behalf of Mount Airy No. 1 LLC.
You may begin.
Thank you. The request that's before you is to revise Mount Airy's audit committee charter to permit one owner to serve on the audit committee. Currently, the charter prohibits an owner from serving on the audit committee. And I'm going to be brief because I'm sure you've read the materials that have been submitted, the briefs. The purpose of an audit committee is twofold. Number one, it's to assist a board of directors in the oversight of a company. And number two, it's to protect the shareholders of the company. Sarbanes-Oxley was passed, as everyone knows, in the wake of accounting scandals at Enron and WorldCom. And in the preamble to Sarbanes, it specifically says the purpose of the act is to protect investors. In addition, the American Institute of Certified Accountants publishes an audit committee toolkit for private companies, and both Enforcement Council and Mount Airy have cited to that publication. And in that publication, it also reinforces what's in Sarbanes, that the audit committee represents the interests of all owners of the business. At Mount Airy, the shareholders are the owners of the company. It's a LLC, so we don't have shareholders, but we have members, and they're the owners of the company. All of the members of Mount Airy are members of the DeNaples family. The board of directors at Mount Airy is called a management committee. It's kind of a misnomer. Again, it goes back to the fact that Mount Airy is formed as a limited liability company. There's managers, so it's called a management committee, but essentially it functions as a board of directors. Mount Airy's audit committee currently is comprised of two members that are completely independent of Mount Airy and the DeNaples family. The chairman is Lance Cole. He's a professor at Dickinson School of Law, and he's a director of Dickinson Center for Government Law and Public Policy. The second member is Pat Ross. He was formerly a teacher for 23 years and supervisor of Pocono Township for 20 years, and he currently runs a consulting company that assists businesses in business development. Unfortunately, the third member passed away. He was a CPA, former employee of the IRS, and that's what precipitated the current request to fill that spot. And what's contemplated right now is to add Dr. Louis DeNaples Jr. As a member of the audit committee. He's highly qualified. He's currently a licensed principal before the board. He is a licensed medical doctor. He's the owner of several medical businesses. He currently serves as a vice chairman of a publicly traded company, also serves on the audit committee, risk management committee, and corporate governance committees of that publicly traded company. He's also a shareholder of that company. The request is not breaking new ground here. The board has permitted and continues to permit another privately held licensee to have one of its owners serve on that company's audit committee. The Enforcement Council's arguments just don't really, it doesn't make much sense, the arguments they're making. The first argument they make is the audit committee must be independent of the board of directors. That's directly contrary to both Sarbanes and the American Institute of Certified Public Accountants publication, because they specifically contemplate that it is the members of the board of directors that are going to serve on the audit committee. Secondly, they say having an owner serve on an audit committee would compromise the audit committee and make its work product suspect. Again, there's precedent for this. And the fact that another licensee is currently doing it, I think belies the argument that OEC is making. And lastly, OEC contends that it's contrary to the existing charter to allow this to happen. That's the whole purpose why we're here. We understand that it's currently prohibited, and any amendments to the charter require board approval, and that's the precise reason why we're coming before you with this request. That's all I have, and I'm happy to answer any questions.
Thank you. OEC, response?
Good morning, Chairman Barish, members of the board. As Mr. Sklar said, Mount Airy is requesting that the board permit one of their owners, Dr. DeNaples, to serve on their audit committee. I'm briefly going to highlight some of the reasons that OEC objects to this request, including that it's contrary to the board's regulations. Having a non-independent member of the committee could create a conflict in the reporting structure for the surveillance, audit, and compliance departments. Their statement of conditions, the board-approved charter, and the board's regulations all require them to have an independent audit committee. And this would be falling in line with the spirit of the best practices set forth by the American Institute of Certified Public Accountants, or the AICPA. I'm just going to start off with the premise. Dr. DeNaples is not an independent individual. He is one of 3 DeNaples family members that serves on the management committee, which fulfills the role of the board of directors at Mount Airy, but he also serves as one of those 3 same family members that is a trustee on the trusts that own Mount Airy's holding company, which owns 100% of Mount Airy No. 1 LLC. He has a 50% ownership interest in one of those 7 trusts, and he is a family member of every other Mount Airy principal, save the 2 current audit committee members. As the board regulations require that the directors of Mount Airy's internal audit and surveillance departments report to an independent audit committee or other designee regarding matters of policy, purpose, responsibility, and authority. Pursuant to the board's authority in Section 465 A11C5, the board, through Mount Airy signed statement of conditions, has designated that the directors of internal audit, compliance, and surveillance report to the audit committee regarding members of policy, purpose, and responsibility and authority. Further, pursuant to this board regulation, the hiring, firing, and the salary of these 3 important directors is set by an independent audit committee, not the management committee. This regulation is in place so that these supervisors of surveillance, independent audit, and compliance have an ability to discuss internal matters and raise concerns where they could be reluctant to do so if management executives are members of the committee. And having them report to an independent audit committee is significant for the policy purposes and responsibility, and having that independent audit committee responsible for hiring, firing, and salary, while the management committee directs their day-to-day operations, ensures independence and prohibits a potential conflict of interest from occurring. Similar to the 3 department heads who I've just talked about, the other 2 members of the audit committee may be hesitant to speak out or voice concerns at a closed meeting if they know that an owner is present who controls their contracts being renewed. Mount Airy's current audit committee charter has multiple controls and clauses which ensure that there's no material relationship between an audit committee member and Mount Airy or of any one of its principals. And having Dr. DeNaples serve on this committee would eviscerate all of those clauses that the board in Mount Airy has put in place to ensure independence. Further, Mount Airy has offered and agreed since its inception to have an independent audit committee. During Mount Airy's initial suitability hearing, through their attorney, they offered to the board that if granted a slot machine license, they would form an independent audit committee which would have the absolute authority and responsibility to monitor and report on the operations and financial controls of the company. As the board knows, Mount Airy was granted a slot machine license by the board in December 2006 and signed its first statement of conditions in April 2007, where they agreed to have an independent audit committee. Mount Airy's initial independent audit committee charter was filed with the board in October 2007 and required that the audit committee members be independent. It also listed 5 financial relationships, which would constitute an individual having a material relationship with Mount Airy, and that would then disqualify the individuals from serving on Mount Airy's independent board of directors. The Mount Airy signed a statement of conditions with the board again in February of 2010, and in September 2012, where they agreed to maintain an independent audit committee. In June 2012, the board issued an order approving a new charter for Mount Airy's audit committee. That charter also continued to place restrictions on who can serve on the audit committee, and including prohibited principals and others who have a material relationship from serving on the audit committee. This was done to keep the audit committee independent for the reasons that we've both talked about prior, and that's listed in our brief. And that is the charter that we are operating under today. It is contrary to the best practices. The AICPA says that the Sarbanes-Oxley requirement that each member of the audit committee shall be a member of the board of directors and shall be independent is a best practice. Unlike the privately or publicly traded companies, Sarbanes-Oxley does not apply to them. It's not law. Mount Airy cannot fully meet this best practice because it doesn't have any independent directors serving on its management committee. Unlike a traditional company, it doesn't also have a board of directors. However, the policy of having an independent audit committee can still work here. The audit committee being independent is significant because it has an important corporate oversight function insofar as it provides oversight to the company's finances, audit, legal, and regulatory requirements, and these may contradict an owner's wishes. Mount Airy argues that they're being treated because at least one other privately owned casino has an owner on its audit committee. However, unlike every other licensee, Mount Airy is the only casino wholly owned by family members. Other slot machine licensees are owned by individuals or entities that operate at arm's length business agreements with each other, and each individual in those operates for their own economic interest in an arm's length transaction with each other. However, Mount Airy is operated by family members who might make sacrifices for each other and who further might be motivated by not by profit, but by mutual admiration and mutual affection. In conclusion, the regulations require that the directors of internal audit and surveillance report to an independent audit committee on members of policy, purpose, responsibility, and authority, and to a management committee on administrative and daily matters. This ensures that there's independence and there's a reduction of risk of conflict of interest. The directors of internal audit, surveillance, and compliance departments could be reluctant to discuss internal matters or raise concerns when they know an owner is present. Mount Airy has agreed to have an audit committee. They offered to have one, and OECT asks that they be held to this requirement. Thank you, and we'd be happy to answer questions.
Thank you. Are there any questions from the board?
Thank you, Mr. Chairman. Mr. Sklar, is the audit committee paid?
Yes, the $40,000 a year. If the board grants a petition, Dr. DeNaples is appointed, he will not be paid.
Okay. Mr. Tepper, what about Mr. Sklar's argument that this board does allow another individual who is an owner of a casino, partial owner, to serve on its audit committee?
I think that OEC and the board takes every instance and every application on its own, and we're here talking about Mount Airy, which is solely owned by one family, rather than a corporation that has people at arm's length transactions. The ownership interests of the individuals are completely different.
And lastly, Mr. Sklar, what are your thoughts or what's your argument about Mr. Tepper's statement that the board order, I believe you said was dated June 12th, limiting who can serve on the audit committee and specifically barring somebody with a financial interest in the casino from serving on that audit committee?
The June 12th, I mean, the requirement about the audit committee dates back, it's not June 2012, it dates back to the beginning of when Mount Airy was licensed. So there's no...
But there was an amendment. I thought that you had said that there was the latest amendment to this board order or something you specified was, I thought you said, was it June 12th or June 2012?
June 2012, there was the board issued an order approving a new charter. Mount Airy redid their audit committee charter around that time, and there were several board orders, the last one being June 12,
Okay.
June of 2012.
And in that board order, did you not state that we limited who could serve on that audit committee?
Yes, I believe the board order states that it must comply with the charter. The charter limits who can serve on the committee.
And one of the bars to who can serve on a committee is that somebody with a financial interest in the casino cannot serve on that committee.
Yes.
All right.
My point was that wasn't a new restriction in June 2012. That was a restriction from 2007.
Okay.
That's where the genesis of it. The way this came up was the passing of one of the audit committee members. The management committee just had a meeting. They discussed, who would fill the vacant spot, and they called me and said, "Can Dr. DeNaples serve?" And I said to them, the audit committee charter right now prohibits it. If that's the direction you want to go in, we're going to have to file a petition and make our case before the board. And that's the sequence here. Can I just make two comments in response to? I promise I'll be brief. I will. The independence requirement for audit committees, it's independent from day-to-day management. That's the independence that's required. So here, Dr. DeNaples is independent from the day-to-day management. Lisa DeNaples is the owner and managing trustee. She does not run the day-to-day operations. That's vested in the general manager, John Coletsu. The regulation that Mr. Tepper cited in terms of the direct reports, he did not include. It's more expansive than just the direct, that those three department heads have to report to an independent audit committee. That's one of the bodies it can report to. It could also report to a board of directors. There is no requirement anywhere in the Gaming Act or the board's regulations that casinos have to have a audit committee. There was a proposed regulation, as some of you may be aware, back in 2008, and it was never adopted. So there is no requirement in Pennsylvania, under the Pennsylvania gaming laws, that requires casinos to have a independent audit committee.
Thank you. Any other questions from the board?
Thank you, Mr. Chairman. Mr. Tepper, I appreciate the fact that OEC looks at each case individually and on its own merit, but would it be fair to say that with the other casino that has an owner on the audit committee, that casino is also more or less controlled by a family?
In this case, no. There are other individuals or entities that it's not one family that would control the facility. So I think it can be distinguished in this case.
They are minor shareholders.
Yes, but in this case, Dr. DeNaples is family members of all, and a trustee of all the other trusts for the 100% owner, Holdco, of Mount Airy Casino.
But the individual on the audit committee is employed by the casino also?
We'd have to look into that. I'm sorry. I'm sorry.
Sugar House.
You're referring to the other casino?
Yes.
That individual is not employed by the casino. He is part of the management committee of the casino, the management company of the casino.
So he's employed by the management company
Right,
of the casino.
And he is not a family member of any other individual that owns the casino.
Okay, thank you.
Any other questions?
Perhaps this has already been stated, but just to make it clear, as I understand it, this other casino isn't required by the board to have an audit committee, isn't that correct?
The board does not require any casino other than this casino to have an audit committee.
Okay.
All the other casinos have an audit committee.
Okay.
We're going to take a 10-minute recess. Thank you. Thank you for your patience. Next, we have a motion to approve the minutes and transcripts of the January 13th meeting. May I have such a motion?
Yes, Mr. Chairman, I move that the board approve the minutes and transcript of the January 13, 2016 meeting.
Second.
All in favor?
Aye.
All opposed? Motion is adopted. Kevin, we're on to new business. If you come forward.
Mr. Chairman, members of the board, I've asked Director Liz Lanza of our Office of Compulsive and Problem Gambling to give a brief presentation and a resolution regarding Compulsive and Problem Gambling Awareness Month. Liz?
Thank you. Good morning, Chairman, members of the board. Before you today is a resolution proclaiming March as Problem Gambling Awareness Month, or PGAM. The National Council on Problem Gambling created PGAM in an effort to raise awareness on the perils of gambling disorders. While it is recognized that around 90% of the population can gamble responsibly, there is a percentage of individuals who have developed a gambling problem or are at risk of developing a gambling problem in their future. Many members of the public still do not recognize problem gambling as an addiction. Those who participate in PGAM realize the importance in publicizing the signs and symptoms of problem gambling. Board employees will be hosting an information table inside the state capitol during several days in March to provide problem gambling outreach to lawmakers, their staffs, and the general public. Through sponsorships and registration grants, the board, along with the Pennsylvania Lottery and the Pennsylvania Department of Drug and Alcohol Programs, are supporters of the Council on Compulsive Gambling of Pennsylvania's annual statewide conference held during PGAM. By spreading the word to citizens within the Commonwealth, the board recognizes the importance of identifying individuals with gambling disorders and providing tools like the board's self-exclusion program and treatment options to these individuals and their families. For more information on these tools or to find local treatment providers, I urge those affected to call the Council on Compulsive Gambling of Pennsylvania's 24-hour helpline by dialing 1-800-848-1880. And if the board pleases, I will read the resolution into the record.
Please.
Whereas the legislative intent of the Pennsylvania Racehorse Development and Gaming Act recognizes in part that the public interest of citizens of this Commonwealth and the social effect of gaming shall be taken into consideration in any decision or order made pursuant to the Gaming Act. And whereas the Pennsylvania Gaming Control Board recognized the social effect of gaming when it created the Office of Compulsive and Problem Gambling to conduct research, develop public outreach efforts, work with the Pennsylvania slot machine licensees to develop and implement problem gambling programs at licensed facilities, administer the PGCB's self-exclusion program, and promote problem gambling education programs in this Commonwealth. And whereas the Gaming Act established a special fund to be known as the Compulsive and Problem Gambling Treatment Fund and required that all money in the fund should be expended for programs for public awareness, prevention, research, assistance, and treatment of gambling addictions. And whereas problem gambling is a public health issue affecting Pennsylvanians of all ages, races, gender, and ethnic backgrounds in all communities. And whereas problem gambling is treatable and treatment is effective in minimizing the harm to individuals, families, and society as a whole. And whereas numerous individuals, professionals, agencies, and organizations in Pennsylvania have dedicated their efforts to the education of the public about problem gambling and the availability of effectiveness of treatment. And whereas promoting awareness of problem gambling is an opportunity to educate the public and policymakers about the social and financial issues related to problem gambling. And therefore, the Pennsylvania Gaming Control Board hereby recognizes March 2016 as Problem Gambling Awareness Month. We encourage all citizens to learn more about the signs of problem gambling and to help spread the message about the availability of treatment.
Thank you. Any questions, comments from the board? May I have a motion?
Mr. Chairman, I move that the board approve PGCB Resolution 2016-1-CPG as described by the Director of Compulsive and Problem Gambling.
Second.
All in favor?
Aye.
All opposed? The motion's adopted.
Thank you.
Next, we have Office of Chief Counsel. Doug?
Good morning, Chairman, members of the board. Our first agenda item relates to a statement of policy, which Assistant Chief Counsel Susan Yoakum is here to present.
Good morning, Chairman, members of the board. The statement of policy before you today is Statement of Policy 125-199. This statement of policy will add a new side wager, the Blackjack Match Progressive Wager, to the game of Blackjack. With this wager, players win if either of their first two cards dealt is an ace, and they win a progressive jackpot amount if both the player and the dealer have matching blackjacks. Included in this regulation are the rules of play and the permissible payout odds. I'd be happy to answer any questions you may have.
Questions from the board? I have a motion.
Mr. Chairman, I move that the board adopt the statement of policy number 125-199 as described by the Office of Chief Counsel.
Second.
All in favor?
Aye.
All opposed? Motion's adopted.
Thank you.
Today, we have one complaint filed by the Office of Enforcement Counsel and one petition filed by Mount Airy on the agenda. Oral argument on each of the matters was heard by the board earlier today. Additionally, as to each of the matters, the board has, in advance of this meeting, been provided with the pleadings as well as the stipulations filed of record. The first matter for your consideration pertains to a complaint filed by the Office of Enforcement Counsel, which requests this board to impose a civil penalty against Greenwood Gaming and Entertainment Incorporated, arising from OEC's contention that Greenwood failed to provide timely notification of their intent to enter into a proposed restructuring of debt. In lieu of an evidentiary hearing, the parties entered into a joint stipulation of facts, which is part of the record before you. Additionally, as noted just a short time ago, the board heard argument from the parties. The record is now closed and appropriate for the board's motion.
Any further questions or comments from the board at this time? Can I have a motion, please?
Mr. Chairman, I move that the board issue an order to deny the Office of Enforcement Counsel's complaint for judgment and penalties against Greenwood Gaming and Entertainment, Inc.
Second.
I'd like to take a roll call on this. Mr. Ryan, obviously.
Aye.
Aye. Tony?
Aye.
Greg?
Aye.
Opposed?
Opposed, okay.
Aye.
Aye.
And the chair votes opposed. Where are we in terms
There
of...
would be a 5-2 vote. Because it's a disciplinary action, it's a simple majority under the Act and not a qualified majority, so the motion to deny the enforcement action carries.
Thank you.
Next before the board is Mount Airy's petition to modify its audit committee. Specifically, Mount Airy is requesting that the board approve an amendment to its independent audit committee charter to allow an individual with a vested ownership interest in Mount Airy to sit on the Mount Airy Independent Audit Committee. Presently, the board requires that 3 to 5 members be on the committee, and it be comprised entirely of individuals unassociated with Mount Airy's ownership. Excuse me, the Office of Enforcement Counsel objects to the request, arguing that the presence of a person with ties to Mount Airy on the Independent Audit Committee would essentially avoid the independence. The board has heard oral argument on the petition earlier today. Stipulation facts has been previously put into the record by the parties, and this motion is ready for the board's consideration. As opposed to the last one, this motion would require a qualified majority to approve the Mount Airy petition.
Okay. Any further questions or comments from the board? Can I have a motion, please?
Mr. Chairman, I move that the board issue an order to approve the petition of Mount Airy No. 1 LLC to modify its audit committee.
Second.
Roll call. Mr. Ryan?
No.
Tony?
Aye.
No.
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 Aye.
And the chair votes no.
So there's no qualified majority to support the Mount Airy petition. The result would be that the status quo remains without the new audit committee member.
Thank you very much.
Next, presenting reports and recommendations is Deputy Chief Counsel Steve Cook.
Morning, I think. I'm not sure.
20 more minutes.
Next before the board are 7 reports and recommendations received from the Office of Hearings and Appeals. These reports and recommendations, along with the complete evidentiary record for each matter, have been provided to the board in advance of this meeting. Additionally, each person to which a report and recommendation pertains has been notified that the board would be taking the matter up today and that he or she could come before the board when their matter was called. If any of those persons are present, I'd ask them to come forward when their matter is called. The first report and recommendation before the board stems from a request to be removed from the voluntary self-exclusion list. Pursuant to findings of fact of the report and recommendation issued in this matter, on February 10th, 2015, an individual with the initials AN entered Sugar House Casino, met with the casino compliance representative, and requested to be placed on the lifetime self-exclusion list. The CCR conducted the mandatory interview with AN and completed all of the required procedures. Thereafter, AN signed an acknowledgement form selecting the lifetime self-exclusion option. Since placing himself on the list, however, AN has violated the self-exclusion list on at least one occasion by gaming at the Parks Casino. On September 8, 2015, AN filed a request for early removal from the voluntary self-exclusion list. The Office of Enforcement Counsel filed an answer objecting to that request, and a hearing was held on November 3, 2015. Both OEC and AN appeared at that hearing and presented evidence. AN essentially testified that he did not fully understand what he was doing on the day he placed himself on the lifetime self-exclusion list and did not recall the CCR going through the process of placement on the list as the casino compliance representative had testified. In the report and recommendation subsequently issued by the hearing officer in this matter, the hearing officer found that AN did not meet his burden, and as a result, the recommendation to the board would be that he remain on the self-exclusion list.
Questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board adopt the report and recommendation issued by the Office of Hearings and Appeals regarding AN's petition to be removed from the voluntary exclusion list, and that AN remain on the list.
Second.
All in favor?
Aye.
All opposed? Motion's adopted.
Excuse me. Daniel Bizzotto is the next report and recommendation before the board today. On June 22nd, 2015, Mr. Bizzotto submitted a gaming permit application seeking work as a table games dealer at Harrah's, Philadelphia. In November of 2015, the Office of Enforcement Counsel issued a notice recommending that the application be denied, given this individual was convicted in New Jersey of a second-degree drug-related crime in 2012, rendering him ineligible to receive a permit under the Gaming Act, has 15 years, had not expired since his conviction of what the Act would categorize as a felony. A hearing was held in this matter on November 17, 2015. OEC appeared, as did Mr. Bizzotto, both offering evidence. Nevertheless, the report and recommendation subsequently issued in this matter recommends that the application be denied, as this individual is ineligible under the Act given his felony conviction.
Questions or comments from the board? I have a motion.
Mr. Chairman, I move that the board adopt the report and recommendation issued by the Office of Hearings and Appeals regarding Daniel Bizzotto's application for a gaming employee occupation permit as described by the Office of Chief Counsel.
Second.
All in favor? Aye. All opposed? Motion's adopted.
The next matter before the board is a report and recommendation pertaining to Brian DiMattia, and I believe Mr. DiMattia is here. If he'd like to come forward, he may. Mr. DiMattia was issued a gaming employee permit on June 30th, 2014, and worked as a table games dealer at Mohegan Sun prior to his suspension by that employer on June 9th, 2015. On June 25th, 2015, the Office of Enforcement Counsel filed a complaint to suspend Mr. DiMattia's gaming employee permit. The complaint alleges that on June 3rd of 2015, Mr. DiMattia was intoxicated, entered into a neighbor's garage, stealing a garbage can and 2 rugs. When questioned by police, Mr. DiMattia informed the police that he had been drinking with friends on the night in question and did not recall very much about what had happened. Nevertheless, as a result of his conduct, he was charged with burglary, trespassing, disorderly conduct, public drunkenness, and criminal attempt. The burglary charge was later dismissed, and Mr. DiMattia was allowed to enter the Lackawanna County Treatment Court program. If he successfully completes that 18-month program, which include intensive drug and alcohol counseling. All of his criminal charges will be dismissed. Mr. DiMattia requested a hearing in this matter, and one was held on November 3rd, 2015. Both the Office of Enforcement Counsel and Mr. DiMattia appeared at the hearing offering evidence. Mr. DiMattia testified that this incident occurred during a bad period of his life and that he was complying with the Lackawanna County Drug Treatment Court requirements, and in fact he had begun treatment even before entry into that program and had been sober for 5 months to that date. Subsequent to the hearing, a report and recommendation was issued recommending that while Mr. DiMattia did show remorse and rehabilitative efforts, that the hearing officer recommended that his permit remain suspended until at least completion of the Lackawanna County Drug Treatment Court program. That is the recommendation before the board. As indicated, Mr. DiMattia is present at the table.
Mr. DiMattia, would you please stand and be sworn in by the court reporter?
I do.
Thank you. Your opportunity to express your views on this matter?
Good afternoon. I came here, thanks for the opportunity to be here today. I sit here, a humble man. I made mistakes. I have taken full responsibility for my mistakes from day one. I've been given a second chance by the courts of Pennsylvania to fix my wrongs and continue down a better path of my life. And for that, I'm very grateful for. I'm 8 months sober this month. I continue in my recovery every day, which is going to be a lifelong process for me and all recovering alcoholics and drug addicts in this country. I've been given a second chance to reconnect with God and have Him back in my life the way I was brought up as a Catholic. I just ask today, please, for a second chance to return to a job that I do care very much about. I'd like to make a career out of. And thank you very much.
Anybody have any questions for Mr. DiMattia? Are you currently employed?
I'm currently still employed by Mohegan Sun Casino.
Oh, so you're
currently suspended.
You're suspended?
Yes, sir.
And so your understanding that if we put you in this position, that you would then begin to get hours?
Yes, they're currently waiting for the response from today to when I'll be able to come back there.
Okay. Thank you. Is there a motion?
Mr. Chairman, I move that the board reject the report and recommendation issued by the Office of Hearings and Appeals regarding the suspension of Brian DiMattia's gaming employee occupation permit, and that Mr. DiMattia be able to retain a valid permit given his strong rehabilitation efforts.
Second.
All in favor?
Aye.
All opposed? The motion's adopted, and good luck to you.
Thank you. Thank you very much.
Shaney Krisnavage is the next report and recommendation before the board today. On August 13th, 2015, Ms. Krisnavage submitted an application for a gaming employee permit seeking work as a cage cashier at the Mohegan Sun Casino at Pocono Downs. Ms. Krisnavage disclosed the criminal history on her application. Based upon that disclosure, the Office of Enforcement Counsel issued a notice of recommendation of denial of her application, and a hearing in this matter was held on October 8th, 2015, with both OEC and Ms. Krisnavage appearing. As determined by the hearing officer in the report and recommendation, the facts underlying Ms. Krisnavage's conviction are as follows. She was arrested and charged on September 9th, 2014 with discharging a firearm into an occupied structure, recklessly endangering another person, and disorderly conduct. These charges were the result of an incident where she and her 8-year-old daughter were threatened at their home by a woman Ms. Krisnavage's then boyfriend was also seeing. Specifically, the woman came to Ms. Krisnavage's home with a knife, showing it to both this woman and her daughter, demanding that Ms. Krisnavage fight her. Ms. Krisnavage, as a result of this conduct, put her daughter in her bedroom, retrieved a shotgun that was given to her by her grandfather, came outside and fired one shot into her own vehicle in an attempt to scare the woman away. Subsequently, the police came and arrested Ms. Krisnavage on the charges I disclosed earlier. Ms. Krasnavage at the hearing did not dispute her criminal record and testified that she did not intend to hurt the woman, but simply to scare her and to protect her daughter. She also testified that this was the only time she had any involvement with law enforcement, which I believe OEC confirmed. She also testified that prior to her seeking employment with the casino, she had a 16-year unblemished employment history, both as the assistant manager of a card store and as a bank teller. Subsequently, the report and recommendation issued in this matter recommends that Ms. Krasnavage's application for a gaming permit be granted given the circumstances underlying her arrest, and that is the recommendation before the board.
Questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board adopt the report and recommendation issued by the Office of Hearings and Appeals regarding Shanae Krasnavage's application for a gaming employee occupation permit, and that Ms. Krasnavage be issued a permit.
Second.
All in favor?
Aye.
All opposed? Motion's adopted.
The next matter before the board is a report and recommendation pertaining to Matthew McDermott. Mr. McDermott was issued a non-gaming employee registration on March 3rd, 2015, and worked as a cook at the Sugar House Casino. On August 18th, 2015, the Office of Enforcement Counsel filed a complaint to revoke Mr. McDermott's non-gaming registration after learning that on June 9th, 2015, he was arrested and charged with several criminal offenses pertaining to the possession of child pornography. A hearing in this matter was held on October 14th. Despite receiving notice, Mr. McDermott did not attend that hearing, and it was held in his absence. The Office of Enforcement Counsel put evidence into the record indicating that he was, in fact, charged with these crimes and, in fact, was convicted. Thereafter, a report and recommendation was issued recommending that his non-gaming permit be revoked based upon the criminal conduct, and that's the recommendation before the board.
Questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board adopt the report and recommendation issued by the Office of Hearings and Appeals regarding the revocation of Matthew McDermott's non-gaming employee registration as described by the Office of Chief Counsel.
Second.
All in favor?
Aye.
All opposed? Motion's adopted.
Shelton Scott is the next report and recommendation before the board today. On August 20th, 2015, the Office of Enforcement Counsel filed a complaint to place Mr. Scott on the exclusion list, alleging that on August 7th, 2015, he attempted to take a chip from a patron sitting next to him while playing poker at the Rivers Casino. Upon being confronted by the dealer, Mr. Scott returned the chip and was allowed to continue play. However, later, a casino compliance supervisor reported that Mr. Scott made an all-in wager while playing poker, but in fact withheld chips in his hand, sneaking them off the table, and after the hand ended, proceeded to put the chips back on the table and attempt to play the next hand, which of course violates the rules of the game. Mr. Scott answered the complaint, admitting his actions, stating that he's intoxicated, and that was the excuse for his conduct. He did not, however, appear at the hearing that was held in this matter on November 12, 2015. As a result of the evidence put into the record at that hearing by OEC, the report and recommendation issued recommends that Mr. Scott be placed on the board's exclusion list, and that's the recommendation before the board.
Questions or comments? May I have a motion?
Mr. Chairman, I move that the board adopt the report and recommendation issued by the Office of Hearings and Appeals regarding the placement of Shelton Scott on the PGCB involuntary exclusion list as described by the Office of Chief Counsel.
Second.
All in favor?
Aye.
All opposed? Motion's adopted.
The final report and recommendation before the board today pertains to Christopher Sierra. On April 23, 2013, Mr. Sierra was issued a gaming employee occupation permit to work as a security officer at Mount Airy. Mr. Sierra is not currently employed at Mount Airy or any other casino in the Commonwealth. However, he still holds his gaming permit. On August 21, 2015, the Office of Enforcement Counsel filed a complaint to suspend Mr. Sierra's gaming permit after learning that on July 27, 2015, he was arrested and charged with several criminal offenses, including felonies relating to a domestic dispute with his wife. A hearing in this matter was held on October 20, 2015, with both the Office of Enforcement Counsel and Mr. Sierra appearing and offering evidence. Mr. Sierra testified as to facts of the domestic incident, which differed substantially from the affidavit of probable cause, which was put into the record by the Office of Enforcement Counsel. That affidavit alleges that he threatened his wife and others with a firearm. Subsequent to the hearing, a report and recommendation was issued by the hearing officer recommending Mr. Sierra's gaming permit be suspended pending resolution of his criminal charges, given he was at that time charged with at least one felony. Public records now show, however, that Mr. Sierra's felony charge was withdrawn on November 2015. The remaining misdemeanor charges remain, however, and the matter is scheduled for trial next month during March of 2016. The charges continue, which Mr. Sierra continues to face, are simple assault involving a firearm, reckless endangerment, and terroristic threats. The matter is now ripe for the board's consideration. Although the hearing officer based his recommendation for suspension on Mr. Sierra's permit, Mr. Sierra facing a pending felony charge which no longer exists, the Office of Chief Counsel believes the underlying facts alleged in the affidavit of probable cause will nevertheless support an ongoing suspension, and we would make that recommendation to the board.
Thank you. Questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board adopt the report and recommendation issued by the Office of Hearings and Appeals regarding the suspension of Christopher Sierra's gaming employee occupation permit in part, and that Mr. Sierra's occupation permit be suspended until at least disposition of his criminal charges as described by the Office of Chief Counsel.
All in favor?
Second.
All in favor?
Aye.
All opposed? Motion's adopted.
And that concludes the matters of the Office of Chief Counsel.
Thank you. Hi, Susan. Office of Licensing.
Thank you, Chairman Barish and members of the board. Before the board today will be motions regarding 629 principal, key, gaming, and non-gaming employees. In addition, there will be the consideration of 12 gaming service provider applicants. The first matter for your consideration is the approval of principal and key employee licenses. Prior to this meeting, the Bureau of Licensing provided you with a proposed order for 4 principal and 12 key employee licenses. I ask that the board consider the order approving the licenses.
No objection.
Questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board approve the issuance of principal and key employee licenses as described by the Bureau of Licensing.
Second.
All in favor?
Aye.
All opposed? Motion's adopted.
Also for your consideration are temporary key employee licenses. Prior to this meeting, the Bureau of Licensing provided you with an order regarding the issuance of temporary licenses for 12 key employees. I ask that the board consider an order approving the licenses.
Enforcement Counsel has no objection.
Questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board approve the issuance of temporary principal and key employee credentials as described by the Bureau of Licensing.
Second.
All in favor?
Aye.
All opposed? Motion's adopted.
There are also gaming permits and non-gaming registrations. Prior to this meeting, the Bureau of Licensing provided you with a list of 442 individuals to whom the Bureau has granted temporary or full occupation permits, and 139 individuals to whom the Bureau has granted registrations under the authority delegated to the Bureau of Licensing. I ask that the board consider a motion approving the order.
Enforcement Counsel has no objection.
Questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board approve the issuance of gaming employee permits and non-gaming employee registrations as described by the Bureau of Licensing.
Second.
All in favor?
Aye.
All opposed? Motion's adopted.
Next, there are recommendations of denial for 4 gaming and 2 non-gaming employee applicants. In each case, the applicant failed to request a hearing within the specified time frame. The Bureau of Licensing has provided you with orders addressing the applicants who the Office of Enforcement Counsel has recommended for denial. I ask that the board consider a motion approving the denials.
Enforcement Counsel continues to request denial in each instance.
Questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board deny the gaming and non-gaming employee applications as described by the Bureau of Licensing.
Second.
All in favor?
Aye.
All opposed? Motion's adopted.
Also for your consideration are withdrawal requests for key and gaming employees. In each case, the license or permit is no longer required. For today's meeting, I have provided the board with a list of 1 key and 13 gaming employee withdrawals for approval. I ask that the board consider the orders approving the list of withdrawals.
Enforcement Counsel has no objection.
Questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board approve the withdrawals as described by the Bureau of Licensing.
Second.
All in favor? Aye. All opposed? Motion's adopted.
Next, we have an order to certify the following gaming service providers: Araya Solutions, Inc., CPC Bucks County, LLC, Janney King of Pittsburgh, Inc., JR MSPD, LLC, doing business as Johnny Rockets, R.A. Kennedy & Sons, Inc., and Wing Lee Grocery Limited. I ask that the board consider the order approving these gaming service providers for certification.
Enforcement Council has no objection.
Questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board issue an order to approve the applications of gaming service provider certification as described by the Bureau of Licensing.
Second.
All in favor?
Aye.
All opposed? Motion's adopted.
Finally, for your consideration, are gaming service provider registrations. The Bureau of Licensing provided you with an order and an attached list of 6 registered gaming service provider applicants. I ask that the board consider the order registering these gaming service providers.
Enforcement Council has no objection.
Questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board issue an order to approve the applications for gaming service provider registration as described by the Bureau of Licensing.
Second.
All in favor?
Aye.
All opposed? Motion's adopted.
That concludes the Bureau of Licensing's matters.
Thank you, Susan. Office of Enforcement Counsel.
Mr. Chairman, members of the board, today we have 13 matters for the board's consideration, consisting of 3 consent agreements, 2 suspensions, and 8 involuntary exclusions. The first matter on the agenda is a consent agreement between the Office of Enforcement Counsel and Greenwood Gaming and Entertainment, Inc. I see Mr. Schroeder is present. Dustin Miller will present the matter on behalf of the Office of Enforcement Counsel.
Good afternoon. At this time, the Office of Enforcement Counsel has a consent agreement prepared for the board's approval. The consent agreement is between the Office of Enforcement Counsel and Greenwood Gaming and Entertainment, Inc. This consent agreement arises from 2 incidents whereby individuals on the board's self-exclusion list entered Parks Casino and received cash advances in violation of the regulations. Parks' approved compulsive and problem gambling plan and a prior agreement made between the Office of Enforcement Counsel and Parks Casino. On March 25, 2015, an individual on the board's self-exclusion list was found gaming at a slot machine inside Parks Casino after she hit a jackpot and her identity was discovered while processing the jackpot. A surveillance review of the self-excluded individual's conduct inside Parks Casino revealed that the individual had earlier sought and received a cash advance at the Racebook simulcast cage window. The self-excluded individual provided her driver's license and a credit card to process the cash advance. At no time did the cashier check the self-exclusion list to determine if the patron was on the list. The self-excluded individual gamed at 4 different slot machines for a period of 97 minutes. On July 9, 2015, an individual on the board's self-exclusion list entered Parks Casino and went to the Racebook simulcast cage window to seek a cash advance. The self-excluded patron provided the cashier with her driver's license and credit card. The cashier did not identify the patron as being on the self-exclusion list and provided the cash advance. The patron gamed in a Spanish 21 table game for 39 minutes before returning to the Racebook simulcast cage window and attempting to procure another cash advance. However, this time a different cashier checked to see if the patron was on the self-exclusion list. After discovering the patron's name on the list, the cashier contacted Park Security, Pennsylvania State Police, and the Bureau of Casino Compliance personnel. They called them to the area. The patron was charged with criminal trespass for being inside the casino while being on the board's self-exclusion list. On December 8, 2015, the parties entered into a consent agreement to settle these outstanding compliance matters. The board approved consent agreements on December 10, 2014 and September 2, 2015 between the Office of Enforcement Counsel and Greenwood relating to prohibited email contact with self-excluded patrons. The terms of this agreement include a provision that Greenwood Gaming and Entertainment, Inc. shall reinforce existing policies to minimize the opportunity for similar incidents to occur in the future. Further, Greenwood Gaming and Entertainment, Inc. shall pay a total fine of $10,000, and in accordance with the board's billing policy, Greenwood Gaming and Entertainment, Inc. will pay a flat fee of $2,500 in investigative fees. These fines and fees shall be paid within 5 days of the consent agreement being approved by the board. Counsel for Greenwood Gaming and Entertainment is in attendance today to answer any questions you may have. Otherwise, the Office of Enforcement Counsel asks that the board entertain a motion to approve the consent agreement.
Thank you. Any comments on behalf of Greenwood?
Good afternoon, Chairman, Commissioners. My name is Brian Schroeder, SCHROEDER. I'm the Assistant General Counsel at Parks Casino. I'll be very brief. I just want to add 3 pieces of information for the record. The first is that both incidents were self-reported by park staff. The second is we have a robust, responsible gaming training program and procedures for our cashiers and simulcast cashiers. Finally, these 2 instances were aberrations of our normal protocol. The 2 employees that failed to check the self-exclusion list were suspended for 1 week, have subsequently been terminated for unrelated matters, and are no longer employed by Parks. And the final piece of information is, during calendar year 2015, there were 26 self-exclusion persons who were identified and caught by our simulcast cashiers and reported to Pennsylvania State Police and Casino Compliance. So these were 2 that did get by, but 26 were caught and identified.
Thank you.
I'd be glad to answer any questions that you may have.
Any questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board issue an order to approve the consent agreement between the Office of Enforcement Counsel and Greenwood Gaming and Entertainment, Inc., as described by the Office of Enforcement Counsel.
Second.
All in favor?
Aye.
All opposed? Motion's adopted. Thank you.
Thank you.
Thank you.
Next consent agreement that we have on the agenda for today is an agreement between the Office of Enforcement Counsel and Mount Airy No. 1 LLC. Assistant Enforcement Counsel David Tepper will present the matter for the board's consideration. See, Mr. Sklar is here on behalf of Mount Airy today.
Good afternoon, Chairman Barish, members of the board. This proposed consent agreement involves Mount Airy utilizing unapproved roulette chips. Mount Airy placed non-value roulette chip series F and G into service without board approval in February 2011, and chipset series I into service without board approval in February 2014. These unapproved chipsets were discovered during a Bureau of Gaming Operations audit, and once brought to Mount Airy's attention, Mount Airy submitted for and received approval for all 3 chipsets in February 2015. At this time, the Office of Enforcement Counsel requests that the board approve the consent agreement between these parties. The terms of the settlement include that within 5 days of the board's order, Mount Airy shall pay a civil penalty of $15,000 for the violations described, and also within 5 days of the board's order approving this consent agreement, Mount Airy shall pay the board $2,500 for costs incurred by OEC, BIE, and related board staff in connection with this matter. And if you have any questions, both myself and representatives from Mount Airy will be glad to answer them.
Mr. Sklar, are you going to be the only person speaking on behalf of Mount Airy today?
I have Dennis Aselta, who's the director of table games, with me.
Just for the record, then, if there's a chance that you're going to be speaking, if you stand and be sworn in, please.
Yes.
Thank you.
I concur in the recitation of the facts from Mr. Tepper. Just a couple other additional facts, just so the board's aware. The on-site CCRs were notified when the chipsets were delivered to Mount Airy. They were present when the chipsets were opened and inspected. The chipsets in question are identical to the chipsets that had been previously approved. The only difference is the letters had changed in the chipsets that are the subject to this consent agreement. And in the monthly and quarterly impressment reports that Mount Airy files with the board, the chipsets in question were listed on there, but the Mount Airy did not seek the approval as required under the regulation. We're available to answer any questions that the board may have.
Thank you. Comments from the board? Questions? I have a motion.
Mr. Chairman, I move that the board issue an order to approve the consent agreement between the Office of Enforcement Counsel and Mount Airy No. 1 LLC as described by the Office of Enforcement Counsel.
Second. All in favor?
Aye.
All opposed? Motion's adopted. Thank you very much for coming.
The third consent agreement on the agenda is an agreement between the Office of Enforcement Counsel and Mountain View Thoroughbred Racing Association, doing business as Hollywood Casino. Assistant Enforcement Counsel John Crow will present the matter for the board's consideration. See, Mr. Quigley is back in Pennsylvania and is making his first presentation before the board since his return. So we're glad to have Mr. Quigley back. And with that, I'll turn it over to Mr. Crow.
Good afternoon, Chairman, members of the board. John Crowe, CROHA for the Office of Enforcement Counsel. The next matter on the agenda for the board's consideration is a consent agreement reached between Hollywood Casino at Penn National Racecourse and the Office of Enforcement Counsel regarding a violation of the Act governing table games procedures. On September 10, 2015, Casino Compliance was notified by Hollywood Security that 8 decks of cards were left unaccounted for on the gaming floor for approximately 3 days. Hollywood Security initially discovered a discrepancy between the opening inventory report that stated the number of decks put into play in the beginning of September 5th and the number of decks that were collected at the end of that day. On September 9th, 2015, a table game shift manager reviewed the card and dice pickup form completed by Hollywood Security on September 6th and compared it to the open tables for September 5th. The table game shift manager traced the 8-deck discrepancy back to blackjack table BJ 407. However, the shift manager and the security shift manager assumed the error was clerical and that the 8 decks had actually been collected. They then incorrectly modified a card and dice reconciliation form, which was initially completed on September 6th. Later, on September 9th, a Hollywood Casino security officer discovered a sealed bag containing 8 decks of cards underneath blackjack table BJ 407. The 8 decks remain on the gaming floor undiscovered for 3 days in violation of the Act and the regulations promulgated thereunder. Furthermore, the count procedures required by the regulations in the Act and Hollywood internal controls were also violated. The Office of Enforcement Counsel and Hollywood Casino respectfully request that this board approve the consent agreement and stipulations of settlement which require that Hollywood implement policy and procedure to prevent similar incidents in the future, that Hollywood Casino pay a civil penalty of $7,500 as well as $2,500 for costs incurred by the board staff in connections with investigations into this matter. And I am available for any questions that you may have.
Mr. Quigley, do you intend to speak at this time?
I can, yes. I'd like to comment on
Would
it.
you please stand and be sworn?
I do. I would just like to say, I just want to assure you that we understand the seriousness of this. We agree. This, quite frankly, regardless of this agreement, it's unacceptable. We have disciplined the employees that were involved. We've also beefed up the process to make sure that it doesn't happen again.
Thank you. Are there any questions or comments from the board? May I have a motion, please?
Mr. Chairman, I move that the board issue an order to approve the consent agreement between the Office of Enforcement Counsel and Mountain View Thoroughbred Racing Association as described by the Office of Enforcement Counsel.
Second.
All in favor?
Aye.
All opposed? The motion's adopted. Thanks for joining us this morning.
It's good to be back in Pennsylvania. Thank you.
Good to see you.
The next 2 matters on the agenda consist of enforcement actions in which the Office of Enforcement Counsel has filed a complaint seeking the suspension of registrations that have been issued to individuals by the board. Each complaint has been properly filed with the board's Office of Hearings and Appeal and properly served upon the individual named in the complaint. The individual named in the complaint failed to respond within 30 days as required by board regulation. As a result, the Office of Enforcement Counsel properly served a request for default judgment and filed the same with the Office of Hearings and Appeal. Thereby, all facts in the complaint are deemed admitted. All filed documents have been provided to the board for its consideration, and the matter is presently ripe for the board's consideration. In each instance, Assistant Enforcement Counsel Kim Adams will provide a brief summary of facts and request the appropriate board action.
Mr. Chairman, members of the board, good morning. The next matter for the board's consideration is the suspension of Alyssa Kane's non-gaming employee registration. Ms. Kane was charged in 1 criminal docket with forgery, access device fraud, and identity theft, which are all felony offenses. In a 2nd criminal docket, she was charged with simple assault. All her charges are still pending. At this time, the Office of Enforcement Counsel is requesting that Ms. Kane's non-gaming employee registration be suspended pending the final disposition of the criminal charges.
Questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board issue an order to approve the suspension of Alyssa Kane's non-gaming employee registration until at least disposition of her pending criminal charges, at which time she may petition to have the suspension lifted.
Second.
Questions or comments from, I'm sorry, I did that already. All in favor? Getting punchy. All opposed? Motion's adopted.
The next matter for the board's consideration is the suspension of Tamara Thornhill's non-gaming employee registration. Ms. Thornhill was charged in one criminal docket with 2 counts of forgery, which were felony offenses. In the second criminal docket, she was charged with endangering the welfare of children and false identification to law enforcement. Ms. Thornhill's charges are still pending. At this time, the Office of Enforcement Counsel is requesting Ms. Thornhill's non-gaming employee registration be suspended pending the final disposition of the criminal charges.
Questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board issue an order to approve the suspension of Tamara Thornhill's non-gaming employee registration until at least disposition of her pending criminal charges, at which time she may petition to have the suspension lifted.
Second.
All in favor?
Aye.
All opposed? Motion's adopted.
The remaining matters on the agenda consist of enforcement actions in which the Office of Enforcement Counsel has filed petitions seeking the involuntary exclusion of individuals whose presence in a licensed facility are inimical to the interests of the Commonwealth or licensed gaming therein. In each instance, a petition for exclusion has been filed with the Board's Office of Hearings and Appeal and properly served upon each individual named in the complaint. The individual named in the petition failed to respond within 30 days as required by Board regulation. As a result, the Office of Enforcement Counsel has filed a request for default judgment in each instance and properly served the same upon each individual. Thereby, all facts in each petition are deemed admitted, all filed documents have been provided for the Board, and the matters are presently ripe for Board consideration. We will provide a brief summary of the facts in each instance and request the appropriate board action.
Thank you. Glenn Stewart for the Office of Enforcement Counsel. It's S-T-U-A-R-T. Next for the board's consideration is the placement of Erica Gibson Campbell on the board's involuntary exclusion list. On April 12, 2015, Ms. Gibson Campbell tried to access the gaming floor at the Valley Forge Casino Resort using the driver's license of another individual. Ms. Gibson Campbell was only 20 years of age at the time. Valley Forge security stopped Mrs. Gibson Campbell before she could access the gaming floor, so Ms. Gibson Campbell did not wager or consume any alcohol while at Valley Forge. As such, the Office of Enforcement Counsel requests that the board place Erica Gibson Campbell on the board's involuntary exclusion list.
Questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board issue an order to approve the addition of Erica Gibson Campbell to the Pennsylvania Gaming Control Board involuntary exclusion list as described by the Office of Enforcement Counsel. I further move that Ms. Gibson Campbell may petition to be removed from the list after 1 year.
Second.
All in favor?
Aye.
All opposed? Motion's adopted.
Good afternoon, Chairman, members of the board. Benjamin Farrell, F-E-R-R-E-L-L. On the next matter for your consideration is that of Senyu Dong. On October 17th, 2015, Senyu Dong was caught capping wagers while playing blackjack at Presque Isle Downs Casino. At this time, OEC would request that the board place Senyu Dong in the board's involuntary exclusion list.
Questions or comments from the board? A motion, please.
Mr. Chairman, I move that the board issue an order to approve the addition of Senyu Dong to the PGCB involuntary exclusion list as described by the Office of Enforcement Counsel.
Second.
All in favor?
Aye.
All opposed? Motion's adopted.
Afternoon, Mr. Chairman, members of the board, Michael Rowland, ROL-A&D with the Office of Enforcement Counsel. Mr. Chairman, the next 3 matters actually arise all from the same fact pattern. With your permission, I'd ask to give that fact pattern once and then go through to the 3 individuals.
Thank you.
So the first of those 3 matters is a request to place Brian Colucci on the involuntary exclusion list. Mr. Colucci, age 18, used a false identification to try and enter the gaming floor at Sands Casino. Mr. Colucci advised that his friends Jack Ravello, age 21, and David Ravello, age 19, were already inside the casino. Mr. Colucci admitted that he was underage and stated that David Ravello gave him the false identification to enter the casino. Mr. Colucci did not game or drink alcoholic beverages. David Ravello was eventually located in the mall. He admitted that he entered the casino with the same false identification which belonged to his brother, Jack Ravello. David Ravello did not game or drink alcoholic beverages. David Ravello, Jack Ravello, and Brian Colucci were all permanently evicted from the Sands property. Specific to Brian Colucci, he was charged with by the Pennsylvania State Police under 4 PACS 1518, which is our act for unlawful for persons under 21 to wager. He entered a guilty plea on November 16th, 2015, and the matter is now before the board to consider the placement of Brian Colucci on the board's involuntary exclusion list.
Questions or comments from the board? May I have a motion as to Mr. Colucci, please?
Mr. Chairman, I move that the board issue an order to approve the addition of Brian Colucci to the PGCB involuntary exclusion list as described by the Office of Enforcement Counsel. I further move that Mr. Colucci may not petition for removal from the list until his 22nd birthday.
Second.
All in favor?
Aye.
All opposed? Motion's adopted.
Next is the request to consider the placement of David Ravello on the involuntary exclusion list. Specifically, Mr. Ravello was charged also by the Pennsylvania State Police with the same section, 1518, under our act. That's persons under 21 on the gaming floor. He also entered a guilty plea on November 23rd, 2015, and his matter is now before the board to consider his placement, that is David Ravello, on the board's involuntary exclusion list.
Questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board issue an order to approve the addition of David Ravello to the PGCB involuntary exclusion list as described by the Office of Enforcement Counsel. I further move that Mr. Ravello may not petition for removal from the list until his 22nd birthday.
Second.
All in favor?
Aye.
All opposed? Motion's adopted.
And the last of those three matters is a request to place Jack Ravello in the involuntary exclusion list. Jack Ravello was not charged by the Pennsylvania State Police. However, he was permanently evicted from Sands Casino, and the matter is now before the board to consider the placement of Jack Ravello on the board's involuntary exclusion list.
Questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board issue an order to approve the addition of Jack Ravello to the PGCB involuntary exclusion list as described by the Office of Enforcement Counsel. I further move that Mr. Ravello may not petition for removal from the list for at least 1 year.
Second.
All in favor?
Aye.
All opposed? Motion's adopted.
Next is a request to place Fayez Dayoub on the involuntary exclusion list. Mr. Dayoub cheated or attempted to cheat by capping and pinching his bets 7 times while playing Texas Hold'em at Sands Casino. He benefited $380 from his actions. Mr. Dayoub was not criminally charged. However, he was issued a permanent eviction, and the matter is now before the board to consider the placement of Fayez Dayoub on the board's involuntary exclusion list.
Questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board issue an order to approve the addition of Fayez Dayoub to the PGCB involuntary exclusion list as described by the Office of Enforcement Counsel.
Second.
All in favor?
Aye.
All opposed? Motion's adopted.
Next is a request to place Sadil Miranda on the involuntary exclusion list. Mr. Miranda entered the Sands Casino with his son, age 12, and his daughter, age 9. He left his children in the valet area due to them not being allowed on the casino floor while he used the restroom. Instead of returning for his children, Mr. Miranda gamed for approximately 52 minutes. He was issued a permanent eviction by Sands Security, but not criminally charged, and the matter is now before the board to consider the placement of Sadil Miranda on the board's involuntary exclusion list.
Questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board issue an order to approve the addition of Sadil Miranda to the Pennsylvania Gaming Control Board involuntary exclusion list as described by the Office of Enforcement Counsel.
Second.
All in favor?
Aye.
All opposed? Motion's adopted.
And last is the request to place Sanket Patel on the involuntary exclusion list. Mr. Patel gained access to the gaming floor at Sands Casino by presenting his friend's identification to security. Mr. Patel was on the gaming floor for approximately 28 minutes. He was not observed gaming or consuming any alcoholic beverages while on the property. Mr. Patel was permanently evicted, and the Pennsylvania State Police charged him under 1518 of our act. That's, again, unlawful persons under 21 on the floor. He entered a guilty plea to that charge, and the matter is now before the board to consider the placement of Sanket Patel on the board's involuntary exclusion list.
Questions or comments from the board? I have a motion.
Mr. Chairman, I move that the board issue an order to approve the addition of Sanket Patel to the PGCB involuntary exclusion list as described by the Office of Enforcement Counsel. I further move that Mr. Patel may not petition for removal from this list for at least 1 year.
Second.
All in favor?
Aye.
All opposed? Motion's adopted.
Thank you. That concludes our business.
Thank you. That concludes today's business. Our next public meeting will be held on Wednesday, March 2nd, beginning at 10 o'clock in this room. Any final comments from the board? May I have a motion to adjourn the meeting?
So moved.
Second.
All in favor? Aye. All opposed? Motion's adopted.